Welcome back. All right, so let's get back into the prosecution's closing, okay? We want to finish up the closing. I believe deliberations begin tomorrow. We have about an hour to go. I need to be in bed by 10:30. All right, I still have to iron. So let's get started.
And what is protest that the gun that was used in this crime was a Glock 43. It doesn't have to be, but it is consistent with the evidence. And what is clear is that the defendant got rid of the gun.
What's up, Benji? How's your shift going? I watched a little bit of Joe Tacopina's interview with TMZ. He sounded cogent. He sounded reasonable. I did not watch the entirety of it. I still question why he is being interviewed before. I don't know. I don't know why he's being interviewed before they almost have the verdict. It doesn't make sense. But at least he did make sense. He made a little sense in the TMZ interview. He basically said that with jury verdicts, you just never know. You never know. Okay, so Benji's almost done. That's great.
After the incident. Now, he says the gun he got rid of was a prop gun.
Okay.
That's not what the evidence shows. He got rid of that 9mm, the magazine that went with it. But he clearly forgot that in his closet was a second magazine for that gun. A magazine that clearly was not being used in that gun and very well might have been new because he was using the magazine that was in the gun when it was fired.
So Brooklyn says what he mentioned earlier was a different channel. TMZ came later. No, I understand. I don't know what channel you're referring to, but I did watch the TMZ or part of the TMZ interview because it was recommended to me thanks to the algorithm. I'm surprised because when I was watching it, I was thinking to myself, I'm surprised Brooklyn did not mention that Tacopina is in a room with no wall art. I don't know. That just sounds like something you'd have focused on. Maybe not, but that's the first thing that came to my mind. Did you watch the TMZ interview or no?
Relevant. So Lou's version is completely impeached, but it's even worse than that. So they apparently have this information. 12E and Lou have information about this product that will completely prove that the defendant did not commit this crime. And when does it get turned over to prosecutors and police for the first time? January 20th, the day before this trial started. Now they say, oh no, but actually, we told them about it in August 16th or 17th.
But is that Jerome? Jerome said, be careful with a prop gun. If you shoot, it's going to bang. But if somebody shoots back, what are you going to do then? I don't know. Jerome was in tune with this chat. He was, he was very involved.
2024. That's still almost 3 years after the incident occurred. Remember, ASAP Lou is at the house when the search warrant is served. He didn't even have to go to the police. All he has to do is say, hey, you know what? That magazine, that 9mm magazine, that's mine. By the way, it was a prop gun that he had. Nothing. You know why he didn't say it? Because he hadn't made up the defense yet. That's why. Do you know why 12 didn't say anything? Because he hadn't made up the defense yet. That's what the evidence shows. And then what happened? Literally on February 9th, the morning that Lou was going to testify, we are given information. Oh, it turns out.
Okay, Brooklyn.
That Lou.
Brooklyn said that man was in a bathroom or basement. Why would it not? It could have been his office now.
Gave the gun to somebody in New York.
Something else.
And that's why they don't have the gun. Now remember, we're finding this out on what is basically the last day of the trial. We don't have the ability to get that person. But the defense, that's someone they've known about all along. Where is he to testify about this gun? They're saying we have to bring this person out here when there's no reason to believe that anything that person is going to say is true. But we're supposed to bring that person out here who we don't even know exists to prove that it's not a prop. I'm sorry, that it's not a prop gun when that's their witness. Do you not think for a moment that if that witness could have withstood cross-examination, they would have brought him out here? Of course they would have. And how do you know that any of this is true? Because you're instructed on it. So the defense spent a long time attacking me, primarily me, attacking Relly.
Okay.
Where is the instruction about evidence that I ended up fabricating? It says if the defendant tried to hide evidence or discourage someone from testifying against him, that conduct may show that he was aware of his guilt. What does that mean? That instruction is because the defendant, by his own, meaning the defense admission, through their witnesses, is that the defendant got rid of the prop gun. The piece of evidence that would demonstrate that he's innocent of these charges, that he got rid of that gun after the incident. The judge isn't going to give that instruction unless that instruction is something you can consider. Not going to do it. What does it say? If the defendant tried to hide evidence or discourage someone from testifying against him.
Brooklyn, what do you make of that instruction? Benji, I'd like to know as well.
That conduct may show that he was aware of his guilt. If you conclude that the defendant made such an attempt, it is up to you to decide its meaning and importance. However, evidence of such an attempt cannot prove guilt by itself. So in other words, just because the defendant got rid of the gun, that's not enough to prove to you by itself that the defendant is guilty of these crimes. But when you put it with everything else, it is a huge piece of evidence. If someone other than the defendant tried to create false evidence, provide false testimony, or conceal or destroy evidence, that conduct may show the defendant was aware of his guilt. But only if the defendant was present and knew about that conduct, or if not present, authorized the other person's actions. Circumstantially, the evidence suggests that ASAP Lou and Twelvey and Wally are not doing this on their own.
Okay.
The evidence, the direct evidence from Wally is that he talked to the defendant immediately afterwards, their conversation.
Wally?
The idea that ASAP Lou and ASAP Twelvey were not having repeated conversations about this incident strains any even idea of reality. You all know that's not true. Of course they talked about it. Obviously, it's a huge incident that occurred. So that is an instruction you were given. It doesn't say anything about Relly. There's no instruction like that for Relly in this case. Flight. If the defendant fled immediately after the crime was committed, that conduct may show that he was aware of his guilt. What does that mean? After the incident, guys, the second incident, he takes off. If it is in fact, if it was simply a prop gun, why is he running? Why is Twelvey running? Why are they getting out of there? Why are they getting rid of the gun? I mean, I'm trying to argue, you guys, why is the sky blue? And I hope that when you're listening to it, I hope you're all understanding this is not a complicated, complex case.
Yeah.
In the end, the evidence in this case, almost all of it, it's not circumstantial. So the video is direct evidence. Direct evidence of what happened. The testimony of the way.
So Brooklyn is saying that he always thinks of the worst case scenario when it comes down to the last minute, but he's hoping that Rocky gets another chance if he's found guilty. What do you mean by that last portion? What do you mean by you hope he gets another chance if he's found guilty? Another chance at what?
Witnesses is direct evidence. Relly's statement on the call is direct evidence. The testimony, as incredible and unreliable as it is, of Wally, of Twelby, and of ASAP Lou is direct evidence. This is not a circumstantial evidence case. About the only circumstantial evidence in this case that you have that matters is circumstantially, we have to prove that the defendant pointed the gun at Relly in the first incident because we don't have it on video. But we've got his gun being pulled out, we have his gun in front of him, and we have Relly in that position. We have him fighting with Relly right before and fighting with him right after. So the only reasonable interpretation of that circumstance
All right, Brooklyn.
is what you're seeing. Defendants fail to call logical witnesses. This is really important. I've mentioned this before. Every argument that the defense made, the defense, and again, I'm not blaming Mr. Tacopina. The witnesses got up here and lied. Mr. Tacopina gets a statement from the witnesses. The witnesses say what they're going to say. He calls them. Mr. Tacopina does not vouch for his witnesses, meaning just as
I'm sorry.
we call witnesses, and those witnesses testify, and you evaluate them. However, it is certainly legitimate.
Wait, I just want to look.
Those witnesses, meaning
Looking
just
at
as we
the
do,
lawyer.
we call witnesses, and those witnesses testify, and you evaluate them. However, it is certainly legitimate that all these individuals that the defense is saying, why didn't the people call them? Those are witnesses that they are saying we have to introduce to disprove their fabricated defense, which we don't have the ability to do because they control that evidence and information. They've got the prop gun, we don't. They have these witnesses, they don't.
What on earth? Brooklyn, is this true? I did not hear this on TMZ. Again, for TMZ, I only watched about 5 minutes of it was like a 9-minute interview. So, okay, so he is the face of a Gucci perfume called Guilty. That is, okay. All right. I don't know. I have questions now. I have questions.
We don't. We have.
Out of all the names they could have come up with, that's what they came up with?
Proven that this was not a problem in every way that we can. It defies common sense, it defies logic, and it defies all the other evidence that we can. Now listen, I'm not blaming the defense for what they've come up with.
Okay.
When life gives you lemons, you make lemonade. Okay? That's what they've tried to do. They have tried to take a case, and they got bad luck.
It's talked about donuts, a dog bite expert or somebody, and now he's talking about
What
lemonade.
they've come up with. When life gives you lemons, you make lemonade. Okay? That's what they've tried to do. They have tried to take a case, and they got bad luck. Imagine, guys, for a second, if we didn't have those video cameras. Imagine what.
Why he's shaking his head. He sees the lawyer shaking the head, so he starts to shake his head. I don't know.
They have tried to take a case, and they got bad luck. Imagine, guys, for a second, if we didn't have those video cameras. Imagine.
I don't know. Something's going on. I don't know what he's thinking.
Imagine what the defense would be. Well, you can't show anything happening. This is all made up. You got nothing. But we have the video. We have the gunshots. That's bad luck for the defendant. And again,
all right, Brooklyn.
That's it.
I don't know. I don't know. It's just I don't quite understand. I don't understand. I guess the way marketing works. Why would it make sense? It's weird, but okay.
Situation he made. That's his life. Now,
And how much of a coincidence could that? I don't know. Let me leave it alone. I'm gonna leave it alone.
one of the things that's going to happen is you're going to go back there, and we talked a little bit about this before. Let's assume that somebody, when you go back there, starts saying, what if, isn't it possible that, could this have happened? You are not allowed to speculate outside the evidence. That also goes for things like, well, gosh, what if Rocky gets prison on this case? I don't want to go to prison. If any one of you feel that yourselves, you need to let the court know, I can't serve as a juror on this case. That's okay. Some of you during voir dire at points said, I don't know about certain things. And if you remember, the judge told different jurors, hey, listen, if at any point in time you cannot live up to your oath, let the judge know. If one of the rest of you decide, I'll give you an example. Let's say someone goes back there and they say, you know what? I really dislike DDA Lilly. I didn't like him when I saw him. He's obnoxious, etc. Whatever. If that is what you are basing your verdict on, it's improper. It's misconduct. If someone says, I'm never going to convict on a case because I don't like Lilly. If it's you and you can't get past it, you need to report yourself to the court. If it's someone else, they need to do it. We don't know if misconduct happens unless you let the court know about it. So if people, yourself, others are not living up to their responsibilities, we need to let everybody know. That goes the same for the celebrity issue, okay? The defendant should not be convicted because he's a celebrity. But he also should not be acquitted because he's a celebrity. He should not be acquitted because he's got a lovely family. He should not be acquitted because he's successful and wealthy. He should not be acquitted because he can go out there and entertain people and make millions of dollars.
Entertain people.
Those are factors I'm not just recommending, you're not allowed to consider those factors. All you're doing is you're going to weigh the evidence in this case, and you're going to come to your decision. Reasonable doubt in this case. So, proof beyond a reasonable doubt is proof that leaves you with an abiding conviction that the charge is true. The evidence need not eliminate all possible doubt because everything in life is open to some possible or imaginary doubt. What does that mean? Well, it simply means that you're going back and you're going to look and you're going to say to yourselves, okay, here's the case that people presented. The people have presented evidence that the defendant used a real gun. Have we proven that it was a real gun? Not just from our case, but from the evidence that the defense put on as well. They've argued this is a prop gun. And when anybody goes back there and says, well, wait a minute, I don't like Relly, I don't find Relly credible. The problem is, what do you need to find Relly credible about?
Okay.
The evidence is they're admitting it's him. They're admitting it's a gun. They're admitting he fired it. They're admitting that's him at both locations.
Okay.
The only thing that they are really disputing is they're disputing that Rocky ever put the gun up to him in the first incident.
That's problematic.
Which, by the way, once he pulls it out and he's pointing it and you can see it, he doesn't have to point it at him, but once that gun comes out in that situation, you can read the elements of 245. They've got it. The second incident is easy. He actually fires the gun. So where exactly is Relly's credibility? Where is it material?
Okay.
It isn't. They have put Relly on trial.
Brooklyn, Benji, do you guys agree with what Lewin is saying here? He's basically saying Relly's credibility is not material because the defense is not denying anything and everything else, but for the gun being a prop gun.
Trial in this case, because in the end, he is a very convenient target. Legally, it doesn't work. Commonsensically, it doesn't work, but that's what they've argued. You can come and should come to the conclusion in this case beyond a reasonable doubt based on the video and based on the defense in this case. But if you need Relly's credibility, the best evidence you have comes from Wally, their witness, and that tape. That's the only thing you need to listen to.
Fever disappeared on Valentine's Day. I hope you had a good weekend.
Testimony in court? That's in court. Everyone knows why we're in court.
What did you say?
The defense in this doubt based on the video and based on the defense in this case. But if you need Relly's credibility, the best evidence you have comes from Wally, their witness, and that tape. That's the only thing you need to listen to. Any testimony in court, that's in court. Everyone knows why we're in court.
All right, Fever. That's good. That's good. That's good. Everybody needs love and affection, okay?
That is the one piece of evidence coming from the defense where there's no argument that Relly knew he was being taped. There's no argument that he had any incentive to be untruthful. And you listen to him and you know.
Fever, I am good. Just a little exhausted today. I'm tired. I worked a lot today. Have used my brain. I'm just tired, but otherwise we are doing great. Okay. Thanks for asking.
What he is saying is true. He is shocked. He is basically telling Wally, dude, I tried to get money from him. He didn't want to give me any money. Why'd you bring the boys in? He won't give me any money. He tried to kill me. He tried to shoot me. No question. By the way, Wally never mentions it's a prop gun because the defense had not been thought of yet. We started off in this case very early on. We started off with the situation with Boomer. And Boomer is a very important illustration of the difference between what's reasonable and what's possible. And as you remember,
what are you looking at? Oh,
we know what happened. We know that the evidence demonstrated that Boomer was the one that got into the trash.
yeah, Fever. It's, I don't usually I don't mind Mondays, but today's just it's one of those days. But I'm off next week, so maybe that's why. Brooklyn says, "What does money have to do with killing who? Who killed who?"
And the evidence has demonstrated in this case, beyond any reasonable doubt whatsoever, that the defendant Keem Ayers, that on November 6th, 2021, that he committed these crimes. I'm going to end with this.
Yeah, do what?
We've done our job in this case. We have.
What on earth is Tuckapina? What is
I'm going to
Tuckapina?
end with this. We've done our job in this case. We have.
Yeah, I do not understand what Tuckapina is doing. I don't know why he's doing it. I don't know. What's going on?
We've done our job in this case. We have. We've put on more than enough evidence through our case, through the cross-examination of witnesses. We've done our job. I'm going to ask you all to do yours.
Okay.
Whether you want to convict the defendant or not, based on the evidence, that's what you're compelled to do.
Yeah.
Because we can't have individuals, you can't have it, deciding that because they're angry or they're upset or they've been disrespected, that they're going to be allowed to go out and shoot at people on the street, on a
Then where should they do it? In the house? Like, what? I understand what he's saying. You guys know I'm foolish.
Saturday night. We cannot have it.
Okay.
As you go back there, and I'm going to say this again, the first thing that I would ask you to do is to decide, was this a prop gun or not? And if you decide it is a prop gun, for those of you who do, you're going to have to get past all of the nonsensical evidence in this case. You need to ask yourselves, are you following the evidence? Are you following your head, or are you following your heart for whatever reason? Once you do that, the case is over, because that means the defense is fabricated. That means it was a real gun. That means you can't believe anything that was said by any of their witnesses. And that means that in the end, the defendant used a real firearm and committed these crimes. Again, as defense counsel stated, I want to thank you all for your time and for your attention. And I too want to thank Judge Arnold. It's not been an easy case. And I want to ask, to the best of your ability, when you go back there, you pretend that he's not ASAP Rocky. You pretend that
I thought they don't know who he is.
For key mayors. And you treat him the way you would treat anybody else who was accused of these crimes with this evidence. And when you return a guilty verdict, that is not on you. That's on him, because that is what the evidence has demonstrated.
Sheesh.
Do not let anybody tell you that you own his conduct. He owns it. On November 6th, he made a very foolish decision, an illegal decision, a criminal decision, a decision that could have hurt.
Oh, I'm sorry, Fiva. Fiva said Core TV audio is horrible. I'm sorry. Okay. And then Fiva says that's the main question. Was it a prop or not? Was it self-defense because he was scared for his life against Raleigh? Fiva, you missed the first part of, the closing. You're going to, if you have time, go back and go watch the replay from earlier on. But in order for the jury to find that Rocky acted in self-defense, they basically have to come to the concession that that was a real gun and not a prop gun. Yeah, the DA was definitely going in. He's not messing around.
Individuals far worse than what happened. And it's your job and your responsibility to hold him accountable. Because if we're not going to hold privileged people accountable, who are we going to hold accountable? Again, thank you for your time and attention.
What else have going on? I guess he's going to, complain about the remarks about holding privileged people accountable. I'm gonna look at Rocky's reaction. I don't know. I am glad. I'm glad that this case has come to an end, because it was just chaotic. I mean, the facts were good again, okay? The facts were good for the defense, because it's not always, from a defense perspective, it's not always the case where evidence can be used to make an argument for the prosecution and the defense, okay? And Rocky got lucky with his judge. There's no question about that, because with that late disclosure of discovery and still being able to put that witness on, he got very lucky with his judge. All right, what are they talking about? Let's see. Okay. No, there's something going on. All right. Okay, how long? Let's see. This actually ended. Okay, it didn't end yet. We still have like 30 minutes. I was going to say this is sooner. ended sooner than I thought. Because had I known this, I would have.
The jury instruction on.
Had I known that it's not that much longer, I probably would have just stayed and, you know, I'd have had one live. And then Fever says privileged people can't get away with a lot. Yeah, and I mean, Lewin is telling them otherwise, so.
The first remark relates to the jury instruction on circumstantial evidence. It's jury instruction number 224. Jury instruction number 224 tells you everything you need to know about circumstantial evidence. There was some question about whether it was shown in its entirety. The entire jury instruction is in 224.
Okay, Fever says the main evidence they have is the video. Testimony from others don't help anything really. Yeah, the video kind of damning. The video for sure. The surveillance that's some damning evidence.
Another thing I want to mention to you is I think it is very obvious that everyone at that table left it all out on the field. Everybody put out 150%.
Yeah.
I think that's very evident. All right. I want to hopefully focus your duties by kind of summarizing something that both sides have mentioned to you. All right. The people have the burden to prove beyond a reasonable doubt that the gun was real.
Right.
If the people have not proven beyond a reasonable doubt that Mr. Mayers used a real 9mm, then the verdict is not guilty. If you do find that the gun was real, then you look at the 5 elements that are listed for assault with a semi-automatic pistol. That's jury instruction 875. You have to decide whether those elements, all 5 elements, have been proven beyond a reasonable doubt. Then also you can consider the jury instructions on self-defense and the defense of others. You have that jury instruction as well. So I'm hoping that this assists you in kind of focusing how you deliberate. All right, I'm going to read the 2 final jury instructions. When I'm finished with this, I'm going to send you to where you're going to be deliberating. You won't be deliberating in the jury deliberation room here for this court. You'll be deliberating in the deliberation room that is from my court, which is Department 115 on the 11th floor. Yeah. So when I release you, I'd like you to go to the 11th floor and go to Department 115. Department 115, it's right there when you get off the elevators. And Alex will meet you up there. He'll escort you into the jury deliberation room. You can take all of your materials.
Eva said it was a crazy, weird case. This was a good case. Again, this was a good defense case because it's not open and shut. Okay, when you have an open and shut case as a public defender or a defense attorney, then it's kind of, you don't get to be creative or there's not enough room. Brooklyn says the record a phone call doesn't help Rocky either. I'm puzzled. I have no idea why Taco Peanut brought that in. And I mean, it may be very well that Rocky gets acquitted, but even if he gets acquitted, even if it's a hung jury, I have no idea why Taco Peanut thought that was a good idea to get Wally up there. It made no sense.
You can set them down and you can leave for the day. On Tuesday, you must be here by 9 a.m. Jury deliberations start at 9 a.m.
Why did court start later?
And when you show up on Tuesday, you're to gather outside the courtroom doors of Department 115 on the 11th floor. Do you want to say something?
Yes.
Same thing?
That's not too much of a problem. Can we start at 9:30?
think she has issue. I'm sorry, but she just have. If she has something going on, maybe it's. Yeah, the judge is disappointed.
Is that what you all want? All right, I'm seeing nods. Yeah, all right, 9:30. 9:30. All right, here are the final two jury instructions.
Okay.
When you go to the jury room, the first thing you should do is choose a foreperson. The foreperson
Yes, whoever they choose for a four-person, it better not be the gun expert. If it's a gun expert, I don't know. I don't know. I don't know about that one. Whoever they pick, usually the four-person is somebody with a strong personality. But okay. Okay, so Fever says you're right. And so, but defense can't really prove anything. I mean, the burden remains on the prosecution.
person should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is your duty to talk with one another and to deliberate in the jury room.
Yeah.
You should try to agree on a verdict if you can. Each of you must decide the case for yourself, but only after you have discussed the evidence with the other jurors. Do not hesitate to change your mind if you become convinced that you are wrong, but do not change your mind just because other jurors disagree with you.
Okay.
Keep an open mind and openly exchange your thoughts and ideas about this case. Stating your opinions too strongly at the beginning or immediately announcing how you plan to vote may interfere with an open discussion. Please treat one another courteously. Your role is to be an impartial judge of the facts, not to act as an advocate for one side or the other. As I told you at the beginning of the trial, do not talk about the case or about any of the people or any subject involved in it with anyone, including but not limited to your spouse or other family or friends, spiritual leaders or advisors or therapists. You must discuss the case only in the jury room and only when all jurors are present. Do not discuss your deliberations with anyone. Do not communicate using social media during your deliberations. It is very important that you not use the internet in any way in connection with this case during your deliberations. During the trial, several items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room when you begin to deliberate. I made arrangements for a screen, a projection screen, to be brought into the jury deliberation that's actually bigger than that.
Okay.
So if you want to review the videos, you'll be able to do that. We're going to need a clean computer, though, that they can use. You've got to connect the computer to the projector, which is connected to the screen. Mark, our audio visual guy, he can show you how to do that if necessary. If you need to communicate with me while you are deliberating, send a note through the bailiff signed by the foreperson or by one or more members of the jury. To have a complete record of this trial, it is important that you not communicate with me except by a written note.
Okay.
If you have questions, I will talk with the attorneys before I answer, so it may take some time. You should continue your deliberations while you wait for my answer. I will answer any questions in writing or orally here in open court. Do not reveal to me or anyone else how the vote stands on the question of guilt or issues in this case unless I ask you to do so. Your verdict on each count and the special finding of the firearm allegation must be unanimous. This means that to return a verdict, all of you must agree to it. Do not reach a decision by the flip of a coin or by any other similar act. It is not my role to tell you what.
Yeah, look at Jerome. Jerome is still up here. Jerome is saying rich people think they can beat the system.
Do not take anything I said or did during the trial as an indication of what I think about the facts, the witnesses, or what your verdict should be.
Why is that surprising, Fever? Fever is apparently surprised the judge did not say that the case is dismissed. On what grounds? Just because he's tired? I'm tired of this bullshit. Brooklyn says a regular person without the money wouldn't get 3 weeks to present this case, maybe half a day of evidence. I disagree with that. Brooklyn.
You must reach your verdict without any consideration of punishment. You will be given verdict forms. As soon as all jurors have agreed on a verdict, the foreperson must date and sign the appropriate verdict forms and notify the bailiff.
Okay.
If you are able to reach a unanimous decision on only one of the charges, fill in that verdict form only and notify the bailiff. Return any unsigned verdict form. To the alternate jurors, the jury will soon be deliberating, but you are still alternate jurors and you are bound by my earlier instructions about your conduct. Do not talk about the case or about any of the people or any subject involved in it with anyone, not even your family or friends, and not even with each other. Do not have any contact with the deliberating jurors. Do not decide how you would vote if you were deliberating. Do not form or express an opinion about the issues in this case unless you are substituted in for one of the deliberating jurors. Will the clerk please swear the bailiff?
Yes, Your Honor. Please raise your right hand. Thank you. You solemnly state that you take charge of the jury and keep them together. You will not speak to them yourself, nor allow anyone else to speak to them on matters connected to this case, except by order of the court.
Oh, he tired.
If you have agreed on a verdict, you will return into court. Furthermore, if you take charge of the alternate jury.
Brooklyn said we can't agree on nothing and it's okay. I mean, I don't know how many criminal cases you have tried as a prosecutor, a criminal defense attorney, a public defender, or how many cases you've presided on as a judge. But I do not agree with the notion that a regular person without money wouldn't get 3 weeks to present this case. You said maybe half a day of evidence. I just don't agree with that notion because I don't think it's true. It's not been my experience. I don't know. Maybe that's how it's done in your courtrooms, but that's just not the case. What's up, old bag? Old bag, you've missed a lot. You missed Sunday. You missed the live earlier today, but you made up for this one. Okay. Did you have a good weekend?
Jurors, keep them apart from the jury, whether it be levying them a cost, up to you otherwise. So help you out.
All right, the case is now yours. Alex is going to meet you on the 11th floor in front of Department 115. He will escort the 12 of you into the jury deliberation room. You can put your materials down and then you can leave for the day. Remember, 9 o'clock Tuesday, 9:30 Tuesday, please be outside the courtroom doors.
Okay.
Not here, Department 115 on the 11th floor. The 4 alternates, I'd like you also to go up to the 11th floor now. And what I'm going to want you to do is to give Deputy Bennett your contact numbers. I assume you all have cell phones? All right, I'd like you to give Deputy Bennett
Actually, not everybody has a cell phone. I learned that recently.
your cell phone numbers so we can reach you in case we need you. And if we do call you, we're gonna need you quickly.
Okay.
So while the jury is deliberating, you can be in the hallway, you can be in the jury assembly room downstairs, you can walk around, you can be in the cafeteria, but you have to be ready, willing.
For folks with social media, I'm thinking about jurors now. For folks with social media, I do not know. Maybe it depends on the algorithm. Obviously, for me on YouTube, this is all I see because they show me all the crime stuff. Maybe it's different on Instagram where if you're just into, I don't know, home decor or something, that's all you see and you don't get to see any of this rocky stuff.
And able to come to the courtroom if you're summoned. All right, you folks are going to be excused now. Take all of your materials. Council needs to remain. We have a couple of council.
Your Honor, what should the alternates do with our materials?
Yeah. You can leave those. We have chairs upstairs. in Department 115. You can just find a spot and you can leave them there. Everybody take all the transcripts, notes.
All right, let's go. Dang, Jerome is really Jerome was busy. He was in there. Jerome was really there.
Mr. Mayor's factors that are listed in the event that aggravating factors that are listed in the event that Mr. Mayor's is found guilty. The aggravating factors that come into play, obviously, if he's found not guilty, the aggravating factors have no relevance to anything. What I want to know is whether, if there is a conviction, how you want to deal with the two aggravating factors.
That's a real conversation. That is a real conversation. Fever says, nah, that's true. I've been locked up a few times and it took me more than 3 months to plead my case. That's why he bailed out. Brooklyn says, three full months. What's up, Jerome Streets? We saw you on Core TV. Let's see. Okay, Old Bag says the weekend was fine, other than she dyed her hair orange. How do you do that? How do you accidentally dye your hair? Or I mean, I did once, but that was yellow, and that's because I bought some really cheap hair dye. I think it was henna, if I'm not mistaken. And I was a teenager though, so you know, it turned my hands and everything yellow for quite some time. All right, Brooklyn says Jerome's in the house, and Tollbag apparently loves Jerome. All right, let's get in here. I had to pause because it's getting real. They're talking about aggravating factors, possibility of conviction. That's a real conversation.
There is a conviction. How you want to deal with the two aggravating factors. What I mean is you want the jury to make a finding as to whether they're true or not, or you want to let the court meet at some time in the future to make that decision. What about all right, in the event that the aggravating factors become relevant, you have a right.
And there's Jerome again. Jerome said keep that music coming.
That is jury determine whether or not the aggravating factors are true, and they have to make that finding beyond a reasonable doubt. Either the jury can do it, or I can do it. Whether the jury does it or I do it, the standard of proof is proof beyond a reasonable doubt. Now, Mr. Tacopina has stated that I can make that decision rather than the jury having to make that decision. Do you understand that?
Absolutely.
Do you waive your right to have the jury make the decision?
Benji, you wanted to hear the man talk. There, he said something. He said something a little bit.
Do you understand that?
Absolutely.
Do you waive your right to have the jury make the decision and agree that I can make that decision in the near future when it becomes necessary in the future?
I do, yeah.
Jordan?
Yes.
Yeah. All right. The next question is readback. If there is a readback, request for readback of testimony.
I don't know. Where are you? We don't see you in court, old bag. We don't, we've been in session for quite some time. You're kind of late. Okay. Fever says Rocky be looking nervous. This is nerve-wracking, okay? Even if there was no surveillance footage, it's coming down to the wire. It's about to, become reality one way or another. But my contention is that a hung jury for the day, it might be a win for Rocky, but that is going to give Raleigh enough time to, get himself together and be prepared.
What I want to know is whether both sides are willing to waive their presence and agree that the court reporter can go into the jury deliberation and provide the readback of testimony.
I think you should have gone with green. I like green better, old bag.
However, both sides will know what that readback is before it's ever provided.
I mean, Brooklyn, it depends on the jurisdiction. I don't know anything about California. But there are instances when not people, but defendants or convicts can turn themselves in at a later date, and sometimes they do take you in. Yeah, sometimes they do take you in. So that's a possibility. Again, I did not really follow the Tory Lanez trial, but was he taken in immediately, or did he have to report at a later date?
I agree. We're fine with that.
I mean, for that Tory Lanez, I was in and out. I did not watch everything from beginning to end because I actually prefer regular people trials. But this one was interesting, a little too dramatic for me, but
Motion and agreeing what's going to be read to them.
Any communication from the jury
I'm that motion.
before it's ever provided.
I agree. We're fine with that motion and agreeing what's going to be read to them.
Any communication from the jury, whether it's a request for readback or a question, will be given to both sides before any response is given to the jury. If there is a request for readback, all of you will know what the request is and will hammer out what readback will be provided.
Go back to me.
All right, again, Mr. Mayor, you have a right to be present for the readback testimony. What would happen is, the
Only
readback
taking a
testimony,
break.
and you would be there, your lawyers would be there, the prosecutors would be there, and I would be there. And the alternative,
Eva, why do you think Megan lied on Tory? That woman had a hole in her foot. Okay, why do you think she
you
lied?
waive your right to be present. So what would happen is, if there is a request for readback of testimony, the testimony
Did he waive his right to be present? I don't know. Maybe okay.
would be provided, but it would be the court reporter going into the jury deliberation room and providing the readback the testimony that is requested. And you won't be in there, your attorney won't be in there, prosecutors won't be there, and neither will I. You understand? You waive your right to be present?
What do you think that Brooklyn?
Join?
Yes.
All right, the last thing is, you waive your right to be
Doing?
prosecutors won't be there, and neither
Hanging out with his kids, maybe.
will I. You understand? You waive your right to be present?
No, I'd want to be there. I'd want to be there every step of the way, baby.
Join?
Yes.
All right, the last thing is, I thought that 1 hour call would be appropriate, meaning that if the jury summons that they have reached a verdict, that the verdict would be read an hour after they have made that notice.
Why? Why? Why should there be a delay?
Do you have any response? Do you think it needs to be more than that, less than that?
I mean, no, it should be fine. I mean, obviously, no, it should be fine.
Oh, that reminds me. Mr. Mayor's, well, under the circumstances, Mr. Mayor's needs to be here within 1 hour also.
Yeah.
All right. People, do you think 1 hour is sufficient?
That's fine.
Oh, I guess the delays in order to get everybody in the courtroom. Got it.
If we could, an hour and a half would be easier, but if the court wants an hour,
Well, I can make it,
90 minutes would help us. I'm guessing.
I'm fine with that. I don't care. That's fine. Once time, that's fine.
all right, we'll do 90 minutes, and if everybody can gather before that, okay? But it'll be 90 minutes from the time that we're notified that there is a verdict.
Ooh,
What I said to the jury, that all of you left it all in the field, I mean that. You all put out 150%. So,
Presto. I'm going to congratulate them, okay? I agree with the judge on that, okay? I mean, the judge's rulings were questionable, but I think based on the evidence presented, what was available, we saw a show, okay? We saw look, some of it I don't agree with. Some of it we could have gone without seeing, especially the knuckle scrapes between Joe Takapina and Lewin. I would have done without it. But other than that, I think this was a good trial. For the folks that thought he was boring, I don't know. I don't know how people thought this trial was boring. I cannot relate. This was a good trial, and again, this was a good trial because it's not a complete blowout. It's not a open and shut case for the prosecution. The facts could be argued either way. I think overall, I think Takapina could have done better. I would have, at the very beginning, I would have preferred to see more of Chad Siegel, but after his redirect of, who did he redirect? Was it? No. I don't think it was Wally. I forget. He redirected somebody, and he was just not landing. He was flat the entire way. So I suppose it made sense for Takapina to be first chair the entire time. His closing again, I didn't grade that closing. I thought it was awful, but it's not evidence, so it doesn't matter. Uh, Luan's closing I also did not grade, but I did like the way that Lewin reasoned with the evidence, the going back and forth. And to me, Lewin's closing was impressive because it was not written. Okay, so that's hard to do. It's hard to do when you don't have a pre-written closing and still be able to be cogent. I mean, Takapina's closing was not pre-written either, but he was just, I don't know where he was going. I think Mr. P. Pazlomek, I think that's it. I think that's his name. Um, his closing again, the beginning of that closing, I don't know what he was saying. He had lost me. But towards the very end, I guess the middle and then the very end, when he came up with a story of the Hulk, I like storytelling, okay? I absolutely love storytelling. That, apart from cross-examination, I like drafting. I enjoy legal drafting. But the story about the Hulk, I thought that was nice. I enjoyed that, and then he, took us to the very end of his closing. Um, I know folks have been interested in knowing what I think the outcome will be. Let me just read these comments quickly. Okay, Old Bag says Brooklyn. I watched some of Karen Reed's juror interview. Very interesting. I'd like to see what you think of it. I did not actually see this, but I saw it floating around. Maybe that's what we get into on Wednesday, Thursday. Yeah, maybe that's what we get into. Let's see. Fever says, okay, because she lied about sleeping with him. So if a woman will lie about something like that, she will lie about anything for real, in my opinion. All right. I don't know anything about those people's relationships, but when I saw the evidence, or at least what was reported, I was like, I don't know that he gets off, but okay. Benji said, I'd rather have accepted a plea deal and been mad rather than go through this trial sweating bullets. Uh, all right, Benji, I have questions for you. And why is that the case, right? Why? I mean, there's a possibility that he could be liable for, some millions of dollars. So if you were in fact, well, I mean, it's money. You can make it back. That's how I feel. With money, you can make that money back. You can make that money back. But what I like about this trial is the fact that if he does get convicted, the prosecution had to prove its case beyond a reasonable doubt. Obviously, there are circumstances where a plea deal, accepting a plea deal, makes sense. But generally, I'm one of those people that's against plea dealing, just because I think that they are coercive. Brooklyn, he needs to go home, hug his kids. Fiva says another delay. They could just close this case, wasting taxpayer people money. All right. Old bag, the judge is going back to listen to this whole trial because he missed out. He missed out on everything according to old bag. Fever, the judge says, stop it. Yeah, I mean, they gave that man. I don't know what they gave him, but they gave him something. Okay, they gave him something. All right, so let's see. Tomorrow is Tuesday. Okay, so I'm not going to follow anything related to this case tomorrow. Again, the way the algorithm works, luckily I am in the future. What I mean by that is I'm a few hours ahead of California. So hopefully the verdict will not, hopefully they would not have reached a verdict by the time that I make it home. Okay. But if they do, this is what we are going to do. If they reach, let me think about it, because I'm trying to figure out what makes the most sense to come up here earlier and just get it over and done with, or come. No, here's the thing. Whether a verdict is reached or not, we will be here 8:45 p.m. Okay, I want to do 8. No, let's do 8:30. 8:30 p.m. Okay, 8:30 p.m. Whether a verdict is reached or not. So 8:30 p.m. tomorrow. I'm not gonna have an earlier live. Okay. If verdict is not reached, we can get into the Karen Reed interview. We can get into the Karen Reed interview. But if the verdict's reached, then obviously we are going to talk about the verdict. Okay. Let's see. What's Brooklyn saying? No, sum it up later. Brooklyn said live is not good. I don't have time to edit, Brooklyn. So if you want me to edit, I'm not, dear. You're not gonna see me at least for two. You're not gonna see me at least for. You're not gonna see me at least for, I don't know, 2 months or something, because that's just how it goes. Um. All right. Phoebe says his, blessings, and then he says good night. Yeah, I'm glad that it's 9:49. I get to go to bed. I still have to iron. So I'm gonna iron, tidy up a little bit, pack my work laptop. Oh, Tooth Fairy. I'm on Tooth Fairy duty. So I need to find an opening. I have to set like a really early alarm because yeah, I have to set an early alarm, and I have to the Tooth Fairy. Anyways, I forgot about that. I need to do some Tooth Fairy things. Okay. So we reconvene up here tomorrow 8:30 p.m. Okay, Eastern time. We'll reconvene. And again, if verdict is reached, then that's what we talk about. If not reached, then if there are questions that were asked, any readbacks or whatever, we get into that. But then we move on to Karen Reed. And then let me see, when is the Karen Reed trial? Was it March? Let's see. Karen Reed trial date. They're talking about some other stuff. Okay, Brooklyn said April 1st. That's kind of far. Yeah, because we're not even in March. Really, on April Fools? All right, so we'll do a bit of Karen Reed, I guess, the juror interview, but I'm ready to get into a really interesting case. Okay, it's going to be really, really, really interesting. And then Fever said, old school. I still iron my clothes, okay? I definitely iron my clothes. And then Fever, okay, I'm finally finding somebody outside of Cali that actually irons clothes. So Fever irons his clothes as well. Brooklyn said April 1st. Yeah, Benji, I go from Cupid to the Tooth Fairy to Santa. Sometimes I'm a medical doctor. I wear a lot of hats. Okay. Brooklyn says 28th is the second Wassel trial. I completely forgot about that. Let's see. Let me look at my calendar. On a Friday? Why would they start the trial on a Friday? That doesn't make sense. Okay. Yeah, I guess we get into the second YSL trial. That would be good to get into as well. Let's see. All right. All right, folks, let's call it a night. Thanks for coming up here, interacting with me. I hope you guys have a productive and fantastic Tuesday. And listen, if your Tuesday is stressful, you're gonna come up here and I'm gonna make you laugh, okay? It's not always guaranteed, but I don't know. I know why I'm laughing right now. I really don't know why I'm laughing right now. But yeah, if your Tuesday is stressful, come up here. I might be able to make you laugh, okay? I might be able to make you laugh. Otherwise, you're gonna leave and you're still gonna be in good spirits, all right? Okay, so good night, folks. Good night, folks. Jerome, Benji, Fever, Brooklyn, my girl Obag, Callie was up here, Jason was up here earlier. All right, folks, I am officially out. Have a good night.